So, Mr. Alligat, let me just start. Isn't what the defense has put forward in their motions enough for us, from a appearance of impropriety standpoint, to go ahead and have a juror interview of with some parameters to be discussed? I mean, isn't that what really we have to do at this point?
Your Honor, we would say no.
Why?
Several things. First off, and they've got several different components here, but all the stuff that's in the original motion is supposition, attack by proxy. They must have done this. They must have done that. This thing was on live the entire time. Everybody saw what was going on. They're assuming things that they can't prove, as we point out in our response. And we also point out at the very beginning, they waived all of that because it was all available for them to see. We know from what we've submitted to the court, Mr. Shapiro was online. We know his wife was extensively online. So if we're going to assume that wives and husbands talk, which is what they want you to do for the juror who was told not to talk with his wife, we have to assume Mr. Shapiro and his wife were talking, and he knew all of this stuff in real time that was going on, and they do nothing about it until after they get an adverse verdict.
Oh, that's an interesting argument. So we were just saying, what we were saying here in chat and what other people were saying were, well, he's only upset that someone on the plaintiff side is talking to the media, or someone who supports the plaintiff is talking to the media. So, but he's not complaining. Shapiro's not complaining that his own wife is doing it. I like this argument that it's clear Shapiro's wife was in real time during the trial scouring through social media, and they would have known what juror number one's wife was doing. So if Shapiro's wife is scrounging through Reddit, scrounging through Facebook, scrounging through all these other places, she would have been aware of what juror number one's wife was doing. So why didn't she? And of course, because her husband is on the team, she obviously would have spoken to her husband about it. So why didn't her husband raise the question at that time? I like that. That's a good argument. If you're going to impute this discussion between juror number one and juror number one's wife because they're husband and wife, well, then Shapiro and his wife should have had the exact same discussions. That should be imputed to them, that she was filling in her husband as to what juror number one's wife was doing. So therefore, he should have raised it and he didn't, so it should be waived. I like that argument. That's a good, solid argument. I like that.
So all the stuff in the first one, I would say, is gone on that basis. And then we go through each of them and tell you and explain why. For example, the creature comforts. That was contrary to what they represent. That was said before the question was asked.
That was a lie.
It's also a very common phrase, as we point out. So each one of these things has a logical explanation. You can't put together 15 things if that's what they're.
That was a lie from the defense that no one, juror number one had asked a question about creature comforts and nobody ever had used that phrase. But it was in one of the expert witnesses' websites, when clearly, it took about 20 minutes for someone to come up with the day, date, and timestamp for the witness that had just used it a few days previously. That was an outright lie by the defense, by the defense lawyers.
There are that have no significance and say, oh, now we've got a big conspiracy. Okay, so that's why I was in the first motion, gone because of that. The second one, with regard to the 2002 notice, over 20 years old, case law is very clear. That's way beyond the time to be relevant to anything. You also can't tell anything that went on from it.
I mean, what if, and I guess it's just a what if. What if it involved, I think it was HRS at the time and not DCF, but HRS at the time. And he being juror one, harbored some view of HRS that he brought forward. Isn't that something that the defense would have been entitled to know about? Why would we have asked the question in the first place on the questionnaire if that wasn't something that we were concerned about?
Your Honor, from what they've submitted to the court, they haven't gotten to the threshold issue of showing anything that went on. I mean, we don't know if he was the complainant or maybe it was the subject of it, but we don't know anything about what was involved there. There's just no background. Plus, it's over 20 years old. Case law, we've cited some cases where things were much less time than that, and the court said it's not material at that point.
Yeah, 20 years removed is pretty remote and irrelevant.
Against DCF. If you harbored something against DCF or HRS, maybe his eye would have been directed toward them and not the hospital. It might have been good for them. So, this is all an after the fact trying to get out of what happened. That's what this is all about. The juror to supplement on the writing of the lettering, I think the court has dealt with that. But if we're talking about using the letters, I have a demonstrative exhibit.
Oh, yes. Yes, he did. He brought a Kiss album. We talked about Kiss. Oh, but okay, points off for bringing up one of the not so great Kiss Alive. That would have been a good one. But Kiss Alive 2, not the greatest Kiss album to bring, but you know, there were many better Kiss albums that could have been brought. But yes, he brought a Kiss album because that was one of the first things we talked about here. It was, yep. And so maybe they're just part of the Kiss army. That's what we brought up. Damn it. Should have been a better Kiss album. Oh, hell. All right. That is awesome. I feel seen because before we were talking about the nauseas, we were talking about Kiss. All right, let's go.
Okay, these letters are commonly used for a long time. Okay, it does not mean it's a Nazi symbol. From what I've read online, 2 of the founding members are Jewish in this group. So,
yeah,
I think that should dispose of that. Then we got a new one this morning.
Devout Jews.
We've seen this. First time we've seen this. It does not, from what we can tell from here, and there's no follow-up. Here's a conviction. Here was a prosecution. Nothing like that. So we don't know if there was any kind of conviction on this.
What are we talking about?
We're talking about this affidavit you got this morning.
See, that's it. That's what I was saying in the beginning. The victim, or has he ever been convicted of a crime? There's no record of any conviction that I could see on that. If you're not convicted of the crime, you're not convicted of the crime. And the same with the 2016 incident. Are you the victim of a crime? Well, if there wasn't a conviction, it was only an allegation. And he wasn't a victim of a crime. He was a victim of an alleged crime, which doesn't seem to be reportable to me.
About a threat by apparently juror one's wife before they were married. It was before they were married. It's a threat by her son or stepson. Anyway, first time we've seen this, it does not show, there's no follow-up. There's not showing of any conviction. There's not showing of any physical harm, any physical crime being committed here. This is, again, just a lot of grasping. It's, again, trying to attack by proxy. Who knew who in the courtroom?
Doesn't matter.
I mean, if this goes where they want it to go, you're not going to have any more married jurors because there's going to be a presumption. Every juror speaks with his or her spouse. So that's just too much reaching. As far as the materiality goes, they said, well, they didn't disclose, so we've met that. No. To your point, Your Honor, they have to show it was material. It's a 3-part test. Even if there was a blatant concealment, it has to be material. And when you don't ask any of the others, and they can't come in here and tell you, oh yeah, we asked everybody that listed this, we asked them. They haven't gone back, they haven't even done that exercise, I think because they know it wouldn't support their view. But
boom, that goes right back to the beginning of this, when the judge said, okay, did everyone else that checked this box, did you go back and talk to them? They couldn't even be asked to go back and do it. They said, we haven't checked that yet. So how do they know? How can they say that it was a material breach when they can't even go back and say, we checked everyone, we went back and we asked more questions of every one of these people that checked that box and we excluded them on that ground? They don't even know if they talked to everybody else that made that. So they're focusing on juror number 1 when they haven't done the same thing, or they're unable to prove that they did the same thing to other people.
But what really happened here is they didn't ask juror number 1 anything because he had a law enforcement background. They were happy to have a law enforcement person on the jury. They're generally conservative. They liked him until, I guess they didn't like some of his questions as things went along. We had the earlier motion, which was properly denied. So I'm happy to try to answer any of the questions, but we don't think there's enough here to do anything.
Well, assume for the sake of argument that I feel that there's a need for a juror interview. So
okay, again, that's him telegraphing this. Okay, just assume that I'm doing this. How do you want me to do it?
Take that assumption. All right. What is the scope? What are the contours for that interview?
I think it would be clear that you would conduct it, Your Honor. First off, we're not talking about a deposition. We're talking about the court conducting an interview. When I've been through this before, that's the way it's always been done. You don't let one side or the other have their way with a juror in the deposition setting. So you would conduct any discussion like that. It would have to be very limited. I mean, this business about I want to get in all the text and all the stuff, that would be unprecedented. Every time after this, there's an adverse verdict. You're going to hear people saying, "Oh, okay, I want to get that juror's text with his spouse or his cousin."
Yeah, there's no way that's going to
Where are
happen.
we going to go with this?
There's no way that the
I
judge
guess
is going to say, turn over all your cell phone
You ask
records.
these jurors every time when they came back, every time. Have they followed your instructions? Have they not discussed the case every morning? They all said yes. I mean, I don't see why an interview would be any different on that. I mean, but that would sort of be the scope of it. I mean, I don't think it's clear you cannot, that no one, court nor us, can delve into the jury deliberation process. At least,
I mean, I guess I'm with you on the thought process is probably something that we don't or shouldn't go into. But if we're talking about a alleged violation of the court's instructions, that's kind of extrinsic to the thought process. It's, did he receive information outside of the courtroom? And isn't that something that we should know about?
And he's already told you he did not, repeatedly. I mean, I suspect if you ask him again, he'll say the same thing.
Fair point.
And they're probably right about that, but I don't think that gives anybody carte blanche to go delve into everybody's personal information. I mean, again, all the things that they talk about in their first motion, which would lead to the interview, that they claim should lead to the interview, are all things that were publicly known. They are charged with knowledge of that. It was on the internet, all those things. They saw who was sitting in the courtroom. They saw this person and they saw the juror's wife. They saw them sitting here.
Well, to be fair, did they know who that person was at the time?
I think they knew who Jules was. That's pretty clear. And pretty clear from Mr. Shapiro's wife's posts. They knew that. And I have to assume Mr. Shapiro and his wife were talking.
Good point. Even the judge is like, let me think about that.
Anything else, Mr. Elliott?
Not unless you have any further questions.